Good evening, everyone. Welcome to the session 23rd of the Delhi State Legal Services Authority Learning Series for all Delhi legal aid lawyers. So, we are at the session 23, and like last time, we said that we will have a continuous session to the Protection of Children from Sexual Offences Act 2002. We are back with part 2 of the Act. So, the focus for today will be investigation, trial, and challenges. So we have with us Director Legal Sampurna Behura from Bachpan, Bachao, Andolan, who would be taking this topic. But before I request her, I would request our Member Secretary, Shri Kanwaljeet Arora ji, to share with you his vision for this part 2 session of today. Over to you.
Thank you, Shreya. A very good evening to my dear friends. So, welcome to 23rd session of this learning series. As Shreya was just mentioning, and as promised, that today's session is a sequel to the last session which we had on POXO. In last session, we had with us Madam Jyoti from Bachpan Bachao Andolan. Today also, we are having Madam Sampurna Behura. She is Director Legal with Bachpan Bachao Andolan, which is an organization you very well know, or each one of us know about this organization. And Madam, being the flag bearer so far as rights of children are concerned, she has filed so many petitions before Honorable High Court as well as in Supreme Court for the rights of the children. Friends, as I told you in the last session, children, they are our assets. They are supreme assets of any nation, for that matter. They are the greatest hope for the future of the nation. One of the greatest achievement of progressive democracies in the last centuries is that all of them, all the democracies in the world, they have recognized the rightful place of the child in the societal fabric, which is very important. Both at international forums as well as domestic policies, positive actions for the child's welfare has been taken, and it can be evidenced by the way United Nations conventions have taken place, by the way our parliament have enacted various laws for the benefit of the children, and the way Honorable Apex Court, that is Honorable Supreme Court of India, and Honorable High Court have given different judicial interpretations, ensuring that all the children should get what they actually deserve. So, child-centric rights jurisprudence that has developed, and that has come a long way, and it has developed as a new dimension to the larger role of law in social engineering. At domestic level, India has made giant strides, good strides in uplifting the position of the children. हम सब जानते हैं that by way of 86th constitutional amendment, education was made a fundamental right for the children so far as age group of 6 to 14 is concerned. And this could be possible, this was possible only as a result of the empathy shown by the public spirited individuals as well as institutions towards the child. Now, many statutes, many laws, they have been promulgated by the parliament so as to make the life of the child easier and enjoyable. And not only laws, we have got a full-fledged ministry of welfare of child and women, working for the welfare of the children of our nation. And besides that, we have got, say, other agencies, other NGOs, so many NGOs, and alongside NGOs, Delhi State Legal Services Authority has always been, say, finding ways and means, devising ways and means to work for the welfare of the children of our country. Besides that, Honorable Supreme Court from time to time, it has enlarged the scope of Article 21, and by enlarging the scope of Article 21, it has included the rights of the children in Article 21 itself. I would just like to mention the observations made by Honorable Supreme Court in Bandhua Mukti Morcha's case, so far as right of children are concerned, and why children are important for progress of any nation, for progress of India. What Supreme Court has observed is that the right to live with human dignity enshrined in Article 21 derives its life breadth from directive principles of state policy, and particularly clauses E and F of Article 39 and Article 41 and 42. They say that protection of health and strength of workers, strength of not only men and women, but of tender age of children, that has to be there against any abuse. Then Supreme Court says that the child of today cannot develop to be a responsible and productive member of tomorrow's society unless an environment which is conducive to his social and physical health is assured to him. So it is very important that we have to ensure a conducive atmosphere for his development. Only then we would be able to see that he develops, he grows into a responsible and productive member of tomorrow's society. Supreme Court further said that every nation, developed or developing, links its future with the status of the child. Neglecting the children means loss to the society as a whole. So, in case we neglect the children today, we are going to face very big consequences of it in the coming future. So, if children are deprived of their childhood, socially, economically, physically, and mentally, the nation gets deprived of the potential human resources for its social progress, for its economic empowerment, for its peace and order, as well as for its social stability. Every child, जो भी बच्चा है हमारे देश में, वो हमारा asset है, and every child has a legitimate claim and is entitled to his share in the finances of the country for the harmonious and comprehensive development of his personality. सिर्फ ऐसा नहीं है that whatever resources of our country are there, whatever budget allocations are there, they have to go only for the adult population. Every child deserves to have his proportion in and has a legitimate claim on that budgetary allocation, and that is required for his comprehensive development. Proper health, education, and environment for the children, that is the imperative need of the hour. That is required if we want our society, our nation to grow into a prosperous and say rich nation. Spending money on education, that is not a waste. If we spend money on the education of a child, that is sort of investment of which benefits we are going to reap in times to come. So it is not an expense on public exchequer, but it is an asset in the longer run. It is the best infrastructure which could be laid for prosperity of any nation. लेकिन अगर हम ground realities को अगर देखें, if we probe the ground realities, we will find that about 42 million children in the age group of 6 to 14, they do not have access to the basic education. दोस्तों, despite the fact, अभी जैसे मैंने बताया that by virtue of 86th amendment, education to this particular age group 6 to 14, that has been made a fundamental duty of all the parents to provide education to the children of this age group. Lekin ground realities, they are alarming. They says that about 42 million children in this particular age group, they do not have access to basic education. And who is to blame for that? We all are responsible. When we had adopted our constitution, we had taken a solemn pledge that we shall grow together. We have assured that liberty, fraternity, and justice should be and would be provided to each and every citizen of our country. And this is part of that only. And in case this is the ground reality, all of us are to blame. We should remember and remind ourselves that it is only the strong, knowledgeable, and virtuous children who can make our country strong and great. and that knowledge we have to provide to the children. Children, they are innocent by their nature, by their tender age, they are vulnerable and they are dependent also. So abandoning children and excluding good foundation of life for them is a crime against humanity. This is what I feel. Millions of children live under difficult circumstances. We all see they live as orphans, they live as street children, refugees and displaced persons. State has to act as guardian of health and strength of these tender age children and to see that they are not abused. And for that, state has come up with various legislations, POCSO, for which about which we would talk about. Our eminent speaker who is there for the day, she will talk about POCSO. That act has been laid down, that act has been enacted. But merely by enacting that act, can we say that state has fulfilled whatever obligation was imposed on the state? Answer is no. We have to see that it is properly implemented, it is properly enacted. Whatever sections are there, whatever roles and responsibilities are fixed on different stakeholders, all those roles and responsibilities should be properly fulfilled. Only then we can say that we would be in a position to protect our children from any potential abuse. So what I'll say is that for full and harmonious development of any child or personality of any child, a child needs to grow in a family environment, an environment of happiness, an environment of love, an environment of understanding. So adult, they cannot barter away the future of the children. There must be conscious and continuous efforts for all concerned to take care of the children so that their wholesome development should take place. Wholesome development of their personality should take place. If we neglect and do not provide or meet the bare needs of their food, health or education, I'm sure that we are going to pay a heavy price in future. So the need to act is now. The place to act, to take action is here. All of us, we are responsible citizens of our country, and role and responsibility is on each one of us to take care of the children. We need to create awareness amongst parents. We need to create awareness amongst masses that why children are important to us, why they should not be abused. But it appears that from the very beginning of the human society, children, they have been exploited, and they have been exploited mercilessly. They have been exploited indiscriminately. Child labor, hum sab jante hain, that is the cheapest labor and the disciplined one. क्योंकि बच्चे शोर नहीं मचा सकते हैं, बच्चे आवाज नहीं रेज कर सकते हैं. Whatever is being told to them at very tender age, वो चुपचाप वो काम करते जाते हैं. That is why they are kept as bonded laborers. Children, they were made to work at home. They were made to work outside, in factories, in fields, in hazardous occupations, in hotels, in restaurants, जो हम day in and day out देखते हैं as domesticates. And children, they have been working even at a very early age of 6 to 8 years. और उनके इतने लंबे working hours होते हैं, and income and whatever they are paid, that is a very meager amount. हो सकता है सिर्फ खाने के लिए दे दिया जाता हो, nothing else. So Constitution of India, it articulates the concern for children, as we can see from Article 15, Article 24, Article 39E and F, Article 51A. Constitution has made a provision that state can come up with special laws, with special legislation, so as to protect the children against any sort of exploitation. And numerous laws, they have been enacted from time to time. लेकिन जैसा मैंने पहले भी कहा कि सिर्फ लॉ इनेक्ट करने से अगर प्रॉब्लम सॉल्व हो जाती तो अब तक हो गई होती. लेकिन problem is still there. If we see around us, if we probe the ground realities, we will find that there are so many children who are still being abused. Right now, when we are talking, there are still so many children who are being abused, who are trafficked from, who are taken away, who are kidnapped from their families, from their parents, and they are taken to different areas only for the purposes of doing menial jobs. They are being abused, and that is required from all of us, that we have to safeguard their interest. We have to take all the necessary actions which we are supposed to take as legal services authority, and we have associated with Bachpan Bachao Andolan, which is an organization working for the benefit of the children across the country, to save their childhood, to save their Bachpan. And for that, as I was telling you, that Madam Sampurna Behura, who is with us, she has filed so many petitions before different courts and have obtained various orders to ensure the rights of children are protected. So I won't be speaking much on the topic, as she's there. She's here to guide us on all these topics, that how investigations is taking place, how trial is taking place. And friends, under POXO rules, all of you are aware, and you are part and parcel of state legal organization, legal services authorities, that it is right of, as say jurisprudence of victimology has developed, now it is a right of every victim of crime to know what is the stage of criminal trial, what are his rights, his or her rights, what compensation he or she is entitled to, when can she get that, at interim, at initial stage, or at final stage, whether the accused, who is accused of the crime, who has done that wrong with him or her, whether his application is listed. Victim has a right to oppose that bail application. Victim has a right to know each and every stage of the proceeding, and you, as part of Delhi State Legal Service Authority, have been representing the victims of such crimes. So I'll just say that we will listen to Madam Sampurna Behura. So I won't take much time. I'll request Shreya to invite the speaker for the day. So thank you very much. Stay safe. God bless you.
Thank you so much, sir. So the speaker, the resource person which we have today for this topic, Protection of Children from Sexual Offences Act 2012, Investigation, Trial and Challenges, is Madam Sampurna Behura, who is the Director Legal, Bachpan Bachao Andolan. She is a long-time human rights activist and a legal expert. She has a doctorate degree from Central University, Hyderabad, and she has got 23 years of experience in handling legal cases involving violation of rights of children, women, tribals, Dalits, and transgenders. She has convened various training programs on the Juvenile Justice Care and Protection Act, POXO, trafficking, and other child-related laws at the CBI, National Police Academy, among others, state judicial academies, and also been a guest faculty for National Law School, Bangalore, Private Law College, etc. She's filed a landmark public interest litigation, Sampurna Behura versus Union of India, 2005, which has changed the course of legal liberty for children in India, and she's also handled more than 500 cases in relation to children, and also been a part of drafting of laws and policies pertaining to children, transgender, tribal, Dalit, environmental issues, and women's rights. We are indeed privileged to have her today with us. With all her experience and exposure, we will just say that we are ready to learn her insight on the topic. Over to you, ma'am.
Thank you, Shreya, and I'm very thankful to the Member Secretary for giving us a chance to come and interact with all. As you very rightly said, the laws are many, but there are still gaps, and gaps are about implementation. Children are suffering and as we see, it's a COVID period, it's a very unusual situation. In this unusual situation, I think the best way is to start with what ended yesterday was a meeting which was organized by laureates and leaders, where children and other and youth and all leaders of the world had come and they had demanded for a fair share for children. Well, the fair share of children talks about giving the right kind of justice to children in spare of all their field, including health, education, legal, everywhere. And when we talk about fair share of children, when it comes to POXO, we see there are a lot of pendency across the country, and a lot of cases which are even genuine cases, they don't even see the light of the day. And because the pendency is so high, and because they don't have access to good litigators or good legal support, most of the case end up in acquittal. So if I hope that we take a pledge and lawyers who are associated with Delhi Legal Services Authority at least will take up and work towards the fair share of children by giving them good legal representation in the field of law, and trying to help children to get access justice, and in the right time and the right frame get convictions in the stipulated time frame. And at least what the population consists of India, the 40% of the population are children. And in the 40% of the population, we have seen the exploitation of children are quite high, and as stated by Member Secretary, and we would also like the lawyers and paralegal volunteers and different stakeholders who are here to take POXO in the right spirit and go ahead and implementation. Well, to start with, when we're talking about trial, investigation, and conviction. The first thing that comes to mind whenever crime, it starts with FIR, lodging of FIR. And in our country, we have seen that, especially in POXO, and especially because most of the time the cases that are reported, I'm not saying it doesn't happen in other sector, like middle class or high class, but we have seen more predominantly the cases have been reported from the lower income group, and because of lack of knowledge, most of the time and also because POXO is such a thing, it happens to an individual, a lot of taboo being attached to it. As a result, there's very late in reporting. And as a result, there are a lot of lacunas and a lot of hindrance in registering a proper FIR. And and this has often, we have seen, it's one of the challenges that we have seen in the court, that defense counsel take it as a plea to say that the delay in registration of cases and delay in registration of FIR is actually it's done knowingly, and it affects the case. And many a times I have seen at the lower trial court level that it ends up in an acquittal thing. However, saying that, there are many directions, whether it's Supreme Court or whether it's High Court, there are directions that delay in FIR should not be considered to be a reason for doubting the evidence in the case of POXO. In the state versus in the Supreme Court, in Ramdas versus State of Others in Maharashtra in 2007, there was a directions given. Of course, that time POXO was not there, but there were sexual abuse cases, there were rape cases. In that, it was a statement was given that delay in FIR should not be hold a ground for acquittal, and if the person gives proper reasoning towards it, why there was a delay, and if not directly, if indirectly in the trial, and this has been upheld in many other directions, and Delhi High Court also, and as well in Supreme Court in Gaya Prasad versus State. In the Supreme Court, this has been upheld that delay in filing of FIR, and if there's indirect reasoning also, that will amount to, and if there's strong evidence, that will amount to conviction, and it will not hamper the conduction of trial. So this presumption that if there's a delay of trial, delay of filing of FIR means there's something wrong, that notion has to be changed. And that has, in fact, Supreme Court has recognized this, High Court has recognized this. So with that, we should, all of us should be prepared that we should also accept that most of the time the cases that happen, as I said, on lower economic group, and it's also a lot of taboo are involved. So it takes a lot for a person to come forward and report a case, especially if there's a minor case, if there's an incest case. It takes a lot, because in the incest case, generally it has seen that the father and the brother, who are the single earning member in the family, for them to come and report to police immediately, it takes a lot of things, and especially on the mother as well as on the child. So this is, and that should not be seen as one of the drawback in the case. But what should be seen is we should be giving reasoning in the court when we are filing the case why there was a delay, and also the whole trial should be based on the evidence, the testimony of the girl that's been taken, because she's the only witness to this kind of heinous kind of crime. So that FIR, as I said, the basis of the first the process of investigation and the trial, it also has to be, there has to be proper guidance to file FIR. There has to proper sequence has to be followed. The time, date, occurrence, accused name, accused detail, the age of the girl, and the detailed narrative has to be a part of the FIR. Many a times it comes to us, like I've been handling so many POCSO cases, but I see that many a times there are a lot of gaps. There's a lot of irregularity in the FIR. For example, if I give you an example, there was a rape case which happened. A girl whose friend had called her to some place. She went there and she was raped by her boyfriend, and then there were some other people. And when she came back, on the way she met somebody and she narrated the incident. And after that, she went back home and told her father, and the next day the FIR was lost. But when police was talking to the girl, or when the police was taking the statement, police forgot to take the middle part where she had narrated the whole incident to her friend whom she met on the way. So this kind of irregularity we also need to see, and we need to do away with it. So as lawyers, when we see that, when the FIR comes to us, we must go through it, and whatever is shortcomings in the FIR, we should also always tell the investigation officer to file an additional copy to it, so that those gaps are covered. And also, if such reasonings are given during the trial, even if there's a gap, but the trial, if the witnesses or if the victim says so, it is also upheld in the court. There are many High Court judgment and Supreme Court judgment on this, that once what has been missed out, but during framing of charges or during that trial, if this has been spoken about, an additional charge should have been filed, and the trial has taken place. So irregularity do impact, but if we are careful, we can also do away with it. So as I said, FIR is the first thing. Then comes a medical part, which is a very important part in the whole process of investigation, because that is one of the most important evidence in cases of POCSO. And as I said, it happens with an individual. So and that individual, as per the CRP and CRPC norm, that one has to go for a medical testing. In POCSO, it talks about medical examination. However, it doesn't talk when there is no consent. We cannot force a girl to go for medical examination if she cannot give her consent. If she's a minor with the consent of her parents, definitely yes, we can. But if still she's resisting, and if she's about 12 years of age, we cannot force her. But there are other evidence which we need to take into consideration. So medical evidence is, although it's a very important evidence, but it's not the conclusive evidence. There can be other evidence which can also lead to conviction. So it is probably that is one of the reason why we don't have any provision in the law where it forces the girl that without her consent, her medical examination can be done. And many a times, defense counsel take this play, and it's a challenge actually, wherever the girl, especially when the age of the girl is 16, 17, borderline age, that time it is a major problem when in the court, and there's no medical examination because the girl did not agree. And defense counsel almost every time we have seen most of the cases, they take this plea that the medical examination has not been done, and on basis of that there has been acquittal. We have seen that the case doesn't stand much strength in the court, and many a time even POCSO are not while registering an FIR. Many a time sections of POCSO are also not added, because the police says because she has not gone, she has not done a medical, how can we say that she has been sexually assaulted? But that is not the only thing. If the POCSO says that her statement is the most important thing. So basis of our statement, we can definitely add sections in the FIR. And whether it stands in the court or not, that depends on the judge and the prosecution. It's not the responsibility of the police to decide कि हम ये पॉक्सो का section नहीं लगाएंगे because she has not gone for medical. Medical definitely helps because it helps for further investigation, but if she's not giving any consent, we cannot force her, and we cannot say that it will not stand. Her version will not stand in the court because she has not done a medical. Another important thing is this: whenever there is a borderline case or elopement case, we should always keep in mind that in our country, and especially Supreme Court also has last year, and it has been amended in the criminal law, it is considered to be a rape if a major has married a minor. So POCSO has to be there irrespective of the fact whether she's agreeing for the medical or not. So looking at that, so I would say the FIR has been the first part. They should, the police should take care that FIR is registered on time, should take care of all the detailed information the girl or the victim or the family that they're sharing. If the girl is not willing to go for the medical examination, one should not force her, and one should not wait to attach the sections of POCSO after doing the medical. That can be done earlier also, and this has been upheld by Supreme Court also, and it has been upheld by the Act itself, and that can be contested in the court, but that nothing stops police from registering that under POCSO, especially in case of a minor and anybody who is below the age of 18. And as I said, it's a POCSO, it's a gender irrespective whether it's a boy or girl, it has to be registered. So the FIR is as a first thing, as I said, the first step of any investigation or any trial. It's a very important thing, and it actually is the base of all in a trial. So we have to be very, very careful what we are putting into FIR. And as lawyers, if we see that there are gaps, we must talk to the IO and get it rectified, or ask the IO to do the additional work and rectify it. Many a times, as I said, that they are very reluctant to add POCSO if medical is not done. That also should be told to them. It has been upheld by the Supreme Court as well as in the Act that you can add POCSO even if there is if the child doesn't agree for going for medical examination, because there are directions from the Supreme Court, and as we say, I mean, anybody having a sexual intercourse with a child below age of 18, irrespective of marriage or no marriage, it will be considered as a rape. And so it's an offense under POCSO, so that has to be there. And now there's one more angle that has come into POCSO, and this year, March 2020, of course, it was there last year also, but now it has been more comprehensive. The section that deals with child pornography. So when we're talking about FIR, we have to be very, very careful. We have to take all the details. We have to take assistance of forensic experts and start the process, and accordingly add the sections into it. So child pornography, in that, of course, medical doesn't help much. It is only on the detection of the computers what has happened, and on the version of the girl that the whole thing is recorded. But yes, here there is another angle of medical that is called forensic interview of the child. Forensic interview of the child not only helps in the child pornography matter, but also in other POCSO matter, where an expert who is ideally from a psychology background or a psychiatrist with advanced degree in psychology or psychiatrist has a session with the child, a very specific session with the child, and takes interview of the child, and accordingly the child then gives a statement or and give the fact of what has happened with her, what are wrong that has happened with her, and then that can be a part of FIR. Now, when I say a forensic interview and a counselor report are very different. FIR is lost, medical is done. Now, when we are doing medical, we should also be looking at a factor that is called forensic factor. Not only in child pornography, but another thing also. One is forensic interview, which I talked about, but the other one is forensic examination, which is done in the FSL lab, that is forensic lab. And what happens after a medical is done, whatever, stresses to collect evidence. The police collects evidence from the clothes of the accused, from the clothes of the victim. Generally, it is seen that, and it's also a challenge that I have seen, most of the time, police, while doing the investigation, this is a part of investigation. Collecting evidence is part of investigation, and for sending the thing to forensic lab, police takes a lot of time. By the time the sample reaches forensic lab, the sample are exhausted. I have handled more than 500 POXO cases, but in most of the cases I have seen, when the forensic lab report comes, the report says one thing, it has expired, it's not readable, samples have expired. So it shows that somewhere that whenever the police is doing the investigation has not been done properly. On time, forensic evidence are not being collected. It is not being properly sealed. So forensic collection of forensic evidence is a very, very important aspect. And it is not only about collecting the undergarments or collecting the dress of the accused or the victim, but also hair, nails, marks in the body. Samples can be taken from the mouth. Samples can be taken from the private parts of the child, and also of the accused. So generally, what I have seen in my experience of handling cases, it is generally taken. The clothes are taken, nails are taken, hairs are taken. But what about mouth? What about the private parts? What about hand? I mean, as per Dr. Locke's theory, it is anybody who comes in a contact with any patch or anything, and there is some kind of evidence. And a crime like this, and especially when there's so much of a violence crime, it is always, there's a very high chance that there will be both the parties will be leaving some kind of evidence on each other's body. It's not on the body, also the place where they have done the act, or a place where the child has been exploited. From there also we can forensic evidence can be collected. So police must keep in mind and must ensure that to send for forensic examination, it is not only the clothes of the accused, but also the swabs from the mouth of the child, so mouth of the accused, the nail, the hair, the place from where the act has taken place, or where the violation has taken place, seizure of those clothes, and it should be properly sealed and sent to forensic lab within 48 hours. Otherwise, it loses its maximum. One can wait is 72 hours, but within 48 hours, you get the best result. So it's a paramount of importance to have a forensic team when you're doing an investigation. And it's also paramount importance to collect the evidence to get conviction in POXO. For example, tomorrow, if during the course of trial, because as I said, POXO has a lot of taboo. A lot of taboo is attached to POXO, especially with the minor children. It is almost it's not only a taboo, but it's a trauma. They go through the trauma again and again when they come to court to depose for it. So many a times they don't feel comfortable. I was handling a case where a child was sexually abused by the grandfather and maternal uncle. And today the child is studying in school and she is in a hostel, but she doesn't want to come before the court. The reason she says, when I go to the court to depose for it, I will be going through the same process again and again. But we got conviction in this case. Of course, the term was less, but we got conviction in this case based on our medical evidence and based on our forensic evidence. And the forensic evidence was very strong. The clothes that we collected, the bedsheet that was collected, and all that had evidence. Had body parts of both the accused as well as the girl, and her 164 statement was very strong, and based on that, conviction took place. It's not that she did not come for the trial; she came for the trial, but as I said in our court, the child-friendly system has now come up, but in last last 1 year. But before that, we did not have any child-friendly court, and she was really harassed to go, because a lot of cases were going on, and she was regularly called to court, so she was not willing to come again and again. But based on this evidence, we could manage to get her conviction, and it also prevented her again revisiting the whole incident again and again. So the forensic evidence is very, very important. Forensic doctors are very important, and looking at the importance of this forensic evidence, Supreme Court in the year 2018 actually came up with guidelines and also allocated funds for this. The first time in a court direction where there was financial applications, financial allocation was also there to set a forensic lab in different parts of the country. So I would request the DLSA and all the SLSs across the country to ensure that this are set up in different parts, because to have a forensic lab near the crime place, it's or in the city itself, it helps a lot to get evidence reach there on time, and it is investigated on time, so that the evidence are not destroyed or it doesn't expire. So it's important that we have forensic lab across the country and in every city. So and also the forensic lab importance is also there when if a child gets pregnant. During that time when the child wants to go for MTP, the tissue of the child can be preserved and given to forensic lab to prove the patronage, and also it helps to prove that the child was sexually abused by the concerned person. So forensic lab establishment is very important. Presence of a forensic investigator with the police is also very important. Collection of evidence as per the forensic is also very important to support the trial and the evidence in the case. That was a medical and the trial thing. Many a time so happens, as I said, FIR is the first thing that happens to start in trial. But many a times we have seen that children or the parents, when there is a very violent act, the child has been severely hurt or anything, the child goes to the hospital, and there the treatment is done, and after that police is called for lodging an FIR. Well, that is also allowed under the law. It is nothing wrong. In fact, in one of my case, one of the defense counsel P was that कि इसमें FIR पहले नहीं हुई थी, पहले उन्होंने private hospital में करवाया, फिर यहाँ आया, यहाँ क्या मतलब government hospital में नहीं हुआ. There is no act which says कि आपको सिर्फ government hospital में करना. You can do it in a private hospital, and act also doesn't say कि पहले hospital जाना या पहले FIR करना है. It can be either of them, and it also depends upon what how is the condition of the child. So once you go to the hospital, and it's when the child goes to the hospital who has been exploited badly, it's a responsibility of the hospital authority to inform the police. Like in this particular case which I was talking about, it was a case of Delhi. It was 5 years back. It had happened in Delhi. The plea the defense counsel took in this matter was that कि जो MLC थी वो private hospital की थी, वो government hospital की नहीं थी. But let me tell you, there are enough Supreme Court judgment which says that any hospital the child goes, the MLC can be done, nobody stops, and it has to be done free of cost. The treatment has to be given free. It shows that how serious is Supreme Court, how serious is the government of India, and when it comes to POCSO, when it comes to protection of children. And defense counsel should not take or should not take advantage of those small things. And if we are not careful, they will definitely take advantage into this. And giving Sakshi judgment and a citation in this case, this demand of the defense counsel was rejected by the court, honorable court, and the case went on for further trial, and still the trial is on. We are hoping for for a good direction in this case. So it is immaterial whether the child goes to hospital first or comes to the police station to lodge an FIR. And when I'm talking about FIR, there was an amendment in Criminal Law Act in 2013 where it says a crime like rape, molestation, any crime that is with women or children. In that case, the victim not necessarily have to come to the police station. The police can go to the victim's house and can take the statement. The victim have to be the police has to make the victim very careful, very comfortable, and in a very careful and sensitive way how to take the statement. In fact, the state versus Virendra in Delhi High Court, there were guidelines. There were 22 guidelines of how to do an investigation and how to do a registration of an FIR. So those guidelines are very important. And in that those guidelines, which mainly focuses, is a victim centric, which focuses more towards creating a conducive environment for the victim and extracting the maximum information from her in a sensitive way. If I say, as I started saying, the FIR is very important, So we have directions, we have guidelines in the Virendra versus State of City, and it was upheld by Delhi High Court. There are 22 guidelines into it, how to go for investigations and how police are supposed to talk to the victim, and how sensitive the police is supposed to be, and what all they're supposed to collect the evidence or material for investigation. And who all they should make, if any witness to it, they should also take into consideration. They should write the name of the witnesses, and they can go ahead. It also talks about having a recording of 164 statement, which is of very paramount importance. But in this pandemic time, when I've seen cases coming of 164 statement have not been recorded, it's actually we are not being fair with the children. Normally, I get this. The sentence from the police that madam pandemic chal raha hai, court mein leke jayenge to covid ho jayega and all these things, so that is the reason why we have not done. But there is a facility of video conferencing. You necessarily don't have to take the child to the court for recording of 164. There are cases before even covid when 164 has not taken place. And in POXO 164 is very, very important. In fact, there are judgments which have relied on 164 and have given the order of conviction in the cases. So 164 is very, very important. And recording of 164 by a magistrate, it can be done either through video conferencing or visiting the home of the child, or going through, if the child is admitted to the hospital, the magistrate can come down to hospital also. And we have seen cases. If I've seen an Nirbhaya case, we saw that where, of course, it was not a POXO case, but it's a sexual assault case where the magistrate came down to hospital to take the statement. And recently, in one case where the child is admitted in the hospital, where the magistrate have gone down to take the statement. So in POXO cases, there is a provision and has been also been upheld by the Supreme Court of India that the magistrate can go and take the statement of the child if required to be from the hospital or the place she is comfortable with. And that was the whole idea of creating a child-friendly court in POXO, was this, that the child doesn't have to suffer. Wherever the child is comfortable, there the statement to be taken. So one aspect of child-friendly court, when we talk about child-friendly court, necessarily doesn't mean only the court premises. It can be the magistrate coming down to the house of the child or doing it through a video conferencing. And every child-friendly court should have this facility for having a video conferencing facility. So, so that not only recording of 164 statement, but other statement. Nowadays, so it has become a common thing because every session is being now taken online, virtual. Today also, I had 3 cases where we had the virtual hearing. So this virtual hearing has become a part of reality now, but it is a part of a POXO court, that is a child-friendly court. If the child is not comfortable coming to court, it can be done through video conferencing. Now, when talking about 164 statement, it's also important that many a time it is so felt that generally police says, or somebody, police says that, and also many a time defense counsel has also taken this plea that कि वहाँ पर कोई और present नहीं होगा. So in camera trial, of course, it's an in-camera thing. But if a child is not comfortable and the child is comfortable with a mother, that is allowed. That is allowed, or an interpreter is required. That is also allowed in 164 statement. And we should ensure, because many a times so happen, the language of the child may be different. The language known to the magistrate is different. So how do they communicate? Every time things cannot happen through sign language. And if 2 people are sitting, of course, they will talk, they will communicate. So the presence of an interpreter and presence of a mother, whoever she is comfortable with, it is also allowed under the law. And the Supreme Court, as well as Delhi High Court, has upheld this in many of the matters. So recording of 164 to be done in a very child-friendly manner, wherever the child is comfortable. It has to be done. It can be done in presence of an interpreter, or mother, or counselor, whoever she is comfortable with. Third, the statement of 164 has to be a part of the charge sheet, but before that, it can also be given to the child and the lawyer who's handling the case. It's very important to know what she has spoken, and as a victim, she has right towards her own statement. So this, the recording of 164, she should be made available. The victim should be made a copy to be made available to the victim by the IO, and it should also be given to the IO to be a part of his charge sheet. And when talking about charge sheet, the investigation has to be concluded within 2 months as per the amendment in the CRPC Act, Criminal Law Act. But as per POCSO, it's now been reduced to 1 month. So from 90 days, it has come down to 60 days, and 60 days, and in POCSO, it has come down to 1 month. So the investigation, because they want that there should be a speedy trial, and the time period to get over the trial is 1 year. And wherever there has been a strong case, where good collections have been there and good evidence has been collected, and on timely evidence, there we have seen even the trial getting over in 15 days, 20 days. MP, we have 2 cases where the trial got over in 15 days and one in 3 days time. And there are cases which have also in Delhi also have got over in 1 year's time. But the reason why it is prolonging is earlier we did not have child-friendly court. We used to have courts which will loaded with many other cases. But now there's a direction that it should be an exclusive POCSO court. No other matter will go on in that case. So I hope that will help to achieve the timeline of 1 year time in POCSO cases. So, and for that, a child-friendly court has to be there so that the child doesn't come in contact with the accused during giving her statement or testimony or during the cross. And while the trial period, also one has to also ensure that when the trial is on, the child doesn't come across the accused, because there are a lot of chances that the accused might intimidate her or might scare her. So and in fact, I'm talking this out of experience, because the accused doesn't only necessarily means that he will shout at her or physically. I mean, he will do something which will scare her. He can do it in multiple ways. It was one of my case where a child was. I had rescued a child, a minor child. She was 6 years old. I had taken her to the court. I still remember it was Dslsa court. It was a winter time for her statement. And somebody from the accused family came from the other side, and he was holding a newspaper. He just flashed the newspaper in front of her, and that made her. And she immediately immediately she refused to give a statement. The reason why we asked her why you're not ready for that, and that time in the court she did not say anything. But while coming back, when we had arranged for counselors who spoke to her, and then we found out that she got scared when one of the accused family members showed her a newspaper, and according to her, if she gives a statement, it will come out in the newspaper. So she refused to go to the magistrate chamber to give a statement. So in the in-camera proceeding starts once you get inside the chamber of the magistrate. But here, before getting into that, she met her on the way at the entrance of the court, and that was enough for her to stop her from giving her evidence. So during the investigation period, we should be during the trial period, we should be very careful to see that the children are not exposed to accused any time during the trial. So that they can give the statement comfortably, and they are not threatened by the accused at any point of time. Their security and their protection should be taken into high priority, and that is the reason why we talk about child-friendly court, where a child is not supposed to come in contact with accused, or accused is also not supposed to see the child there. And courts are being asked to put screens or have separate room for their testimony, both for accused as well as for the child. During the trial, no defense counsel can ask direct question to the child. It has to be through the magistrate. The defense counsel has to put down the question to the magistrate, and the magistrate needs to, if the magistrate feels that question is relevant and should be asked, then that question can be put forward to the child, otherwise not. The magistrate has all the power to stop if the magistrate feels that question is not appropriate for that child. But the problem is, this is there. It has been upheld by the law. They are there in Supreme Court directions. Then the guidelines, also then Xxiii guidelines, then POCSO. But unfortunately, we have seen in the court, and it's one of the major challenges that I face is doesn't happen. I know times are changing, but things are improving, but it doesn't happen in all the cases. Pascal Mazara cases was one case where accused was standing, the defense counsel was standing, and he was constantly bombarding the child with case and judge did nothing. So we, as a lawyer, we need to move an application into this. We need to bring to court notice that this is not appropriate as per the court procedure or as per the Supreme Court orders or the guidelines under the Act. Because if that is the thing, then what's the purpose of having the whole Act? It can go under IPC. Why a normal proceeding should be on as per the CIPC and IPC. But the reason there's a special act, because there is something very gross that has happened, and children are special and who needs to be given protection. So this challenge, whenever we notice this, we are facing this problem. We bring it to the court notice. We write to the court. We can also write to High Court JJC committee about it. And then the councils and other judges are being requested not to follow this pattern, but to follow what is there in the guidelines and the POCSO. However, across the country, this is a big gap that we are seeing. Whether it's UP, in some part of Delhi also I have seen, and it's grossly violated in UP. UP, though, it's beyond the thing. In Karnataka also we have seen that. Maharashtra also, I mean, most of the part in the country that child should be separated from the accused to have a child-friendly atmosphere. Accused defense counsel not to ask questions. These are not happening. They are still bombarding the children with questions. And normally a grown-up human being is scared to come to court. Imagine the mentality and the pressure the child must be going through when he or she comes to the court. But this practice has to end. And as a counsel from the victim side, we must bring it to the court notice that this is against the ethics of the law, or is against the law of the country. And judges are now being sensitized on this, and some part of the country they have become very active. They have taken note of it, and they are moving in a very positive way. And we should, and if any defense counsel does this, we need to bring it to the court notice, and it's actually a contempt of Supreme Court order. So, and that way one can improve the situation by bringing it to the court notice. Recording of 164 statement and other testimony of the child has to be done through video conferencing. That is one of the guidelines. And the child doesn't have to come face accused, as I said. There has to be separate entrance for accused as well as for the child in the trial room. And nobody can ask a direct question to the child. And if anybody is saying it's actually contempt of the Supreme Court order, one can always go against it. One can appeal against it in the High Court. Now, when we are doing this, we also see that when a child is sexually assaulted, it is not that only she who suffers, but the entire family suffers with her. Especially if it's from a lower background, there's a lot of loss of economic. There's loss of economics in the family, loss of financial earning. There's a lot of financial burden because the child also needs counseling. Child also needs to overcome the trauma. And if there's an aggravated assault, the child needs to go to the medical checkup multiple times. So to address this, there's something called victim compensation, which is there in the Act. And in victim compensation, why I'm bringing in the trial part is, reason is it is the special court under the POCSO who has to decide what should be the compensation amount. As per Nipun Saxena order, there was a judgment in Nipun Saxena case that there should be a separate guideline for victim compensation for POCSO victim. However, till the time that comes, it is a victim compensation which is there for women that should be applied. That will be applied to. A person. I mean, if imagine a person coming from a lower economic group, a child, his or her child has been exploited, and once this happens, it's one of the very volatile thing to happen against anybody, and in such circumstances. The financial connection, because the parents are not able to go to the job and things like that, they lose out on earning. And also the medical health is also a factor which is affecting them. There is care. Sometimes there are a lot of, I mean, you also need to rehabilitate the child. There's a lot of taboo attached. For all of this, there is a requirement of rehabilitation. There is also a requirement of compensation. So if the family is not able to earn anything, imagine how they will come to court. how and out of fear, they have most of the time I have seen the parents have this fear, हम कोर्ट इसलिए नहीं जाना चाहते कि हमारे पास पैसे नहीं है, हम कैसे जाएंगे. Of course, there's a provision from the court to pay them when they come to court. That's there, but with that not sufficient, they also lose out because उनको लगता है कि कोर्ट कचहरी में जाना पड़ता है, पुलिस स्टेशन जाना पड़ेगा, कोर्ट जाना पड़ेगा, बार बार हम काम पे जाएं या कोर्ट पे जाएं, whether we should go to work or whether we should go to court. And as a result, they lose out on finances, and if they decide to go ahead of the case. So the victim compensation should be given before the beginning of the trial. There are three ways of giving victim compensation, which has been defined this time when the Act was amended in February 2020. It talks about three kinds of victim compensation. One is immediate, second is interim, and third is final compensation. Earlier it used to be interim and final. Now it is something called immediate compensation. There can be an immediate need which can be given by CWC also as well as DLSA also. There's another thing which is called interim compensation, and for all those except the final one, all those two, it can be for education, it can be for economic loss of the family, it can be for the health, it can be for the counsel. When I talk of health, I also talk about mental health. It also it's also for the counseling support to the child. And so, although the treatments are free, but there's sometimes you need to go to a private hospital, you need to get it in a better way. So the medical, of course, is taken care of, but there are other things like education. Children lose out on school education. A child needs to change their school. For that, there's need of finances. So the immediate and interim money can be released on those grounds. Assessment to be made by there's a format, and which the IO needs to make an assessment to it, and even the public prosecutor can also, or the legal counsel representing the victim can also make an application for the honorable court and place a matter with the honorable court and request for a compensation for the child to be given, and then the magistrate can decide on the amount. There is always a misconception that the minimum compensation or the maximum in the interim should be given is about 50,000 rupees. Actually, I'm sharing this case because recently it happened in one of our case where the judge was convinced that the child needs finances. There's a lot of problem, and the child needs to be rehabilitated, and sometimes it becomes because of fear from the accused family, the child also wants to change the place for the rehabilitation and other thing. There is a recommend finances, but they said as an interim compensation and under the DLSA scheme, we will only be able to scheme. We will only be able to give 50,000 rupees, but that is not the fact. It's a minimum is 4 to 7 lakhs in case of POXO, in case of rape, and not POXO but rape, because POXO has not been it's not been specified in that thing. It has only the Delhi victim compensation talks about rape and crime against women. So going by Nipun Sakhya judgment, we have to accept the Delhi compensation scheme for children. So in case of POXO, it is 4 to 7 lakhs. It is not 50,000. So please keep in mind the lawyers who are handling the cases of POXO. And we have taken up this matter in now High Court, and it's being be heard next week. We have also taken up this matter with DLSA. We're discussing with them to come up with an compensation scheme for POXO as been directed in the Nipun Saxena judgment. But still, I would say provisions are there. We need to make use of it. There is a CWC Child Welfare Committee under JJ Fund also. They can give victim compensation, certain amount from there. So immediate and interim compensation can be given from CWC as well as from DLSA, and the special court has to order the amount that the court feels it's a court is satisfied. Okay, certain amount is fine, and then the court can order the amount. Now, coming to the compensation part, also the court can give order for compensation of rehabilitation. We have one case where a child was brutally sexually assaulted in 2013. In fact, that case was a landmark case because that brought change in the whole policy system of the country. It actually, the whole missing children concept came, and the problem of missing children was recognized and was made an offense, and was included in JJ Act 2015 also, and based on 2013 direction. In this case, State versus Manosa, the child was a minor child. She was a very small child, 3.5 years old child, who was brutally sexually assaulted. and who had gone missing, and police did not do anything, did not register an FIR. And next day, when after I think 72 hours, no, after 48 hours, she was found, and she was found in a very bad state. And that's when the whole conscience of the country went up in a very upheaval movement, and the Supreme Court took up the matter. And there was this thing that immediately a FIR should be lost when a child goes missing. In that case, because there was a lot of threat from the accused, because in POXO cases, what happens, the accused gets arrested, but what about the family members? They are family members, and as I said, most of the time they are from the low-lying areas, low economic region, they stay nearby. So there's a need to rehabilitate that child from that place to some other place, and for that also compensation is needed. And interim compensation can be, the amount can be a good amount, not just limiting to 50,000, can be up to 7 lakhs or 8 lakhs, depending upon the need. And in this case, a good amount was given from, let's say, to this victim for her relocation and rehabilitation. Another factor when we come about trial, we see that many a times when the accused is apprehended, the problem comes about proving the age. Now, age factor is a very important factor, irrespective of whether it's a victim or accused, because it determines the pace of the case and determines how the case will go, whether it will go in the trial court or whether it will go in a child-friendly court or children's court. So the determination of age, it's always been a lot of discussion about it, and now people say, okay, ठीक है, bone ossification test में हो जाएगा. But then bone ossification test कब होगा? Bone ossification test कब होगा? When there's a court order that the bone ossification test to be done. But prior to that, they need to look into the different certificate which the victim has. It can be your birth certificate, it can be school certificate, it can be Aadhaar card, it can be anything. But when I say this, there are also a challenge to it. I know everybody must be thinking the age is a very common thing. Why I'm discussing it? Because the reason why I'm discussing it, as I say, the landmark case that I was talking about, State versus Manosa. In that case, what happened? One of the accused, there were two accused in this case. One of the accused took the plea of jubilanity, and he got bail in this matter. And how he got the pay, well, how he proved his jubilanity? He gave his school certificate. Now, school certificate and this was challenged in the High Court, and the school certificate was called, and when it was examined, it was a certificate which was given by the principal. Well, the Act talks about school certificate, but it doesn't talk about certificate by the principal. It is a certificate which is registered during the administration time. When a child gets enrolled in the school, there's a date of birth is mentioned in the register. That photocopy of register to be admitted is admissible in the court of law, not the certificate by the principal. So that was how his bail order was cancelled, and then he was proved to be a major. He was 21 of years, but his principal had certified him that he is during that time of offense he was 17 and a half years. So he took the plea of jubilanity. But when the matter went to High Court, when the whole investigation was done, the police was given order to do further digging into the certificate. So when the school register was brought in, and it was proved that he was 21 years of age. There are judgments, Supreme Court judgment, which talks that whenever there's a doubt, one should follow the JJ rules, the JJ Act, that is Section 94 of the Act, which talks about age verification. But that is there for accused. But that has been upheld by the Supreme Court that the same will go for the victim also. So for that, verification is required as a bone ossification test, and the bone ossification test is also another which is a test which generally doesn't give you the right age. It actually puzzles you. It is almost like 2 years plus and 2 years minus. It can be 16 to 17 or 17 to 18. It doesn't give you the exact age. In such circumstances, what you're supposed to do? Well, the provision of the law says that the benefit of the doubt will go to the accused. In POXO cases, it is a challenge. It is a challenge. So, because there are Supreme Court judgment which talks that whenever there is a benefit of doubt, it has to go to the accused. So in POXO cases where the accused is trying to take advantage of this, or is trying to prove a jubilant, and if in absence of any other certificate, and if he goes for a bone ossification test, he will get the benefit of doubt, and that's a challenge. And the matter gets shifted to children's court, then he will get minor. The reason why I said challenge, because the accused who are booked under POXO who are minor, their penal punishment is comparatively lesser than what it is in case of adult, and the matter goes to the children's court. So the age determination is a very important factor. There are things, so we should always try to get the certificates of the written documents about the victim. The police must work hard during the investigation to ensure that birth certificate or school's admission certificate, enrollment certificate are there. And in case of absence of all this, with bone ossification test, there can be observation from a panel of doctors, and also in some cases efforts have been taken, and because court have acknowledged that prior to 80s or even to the 90s also, there were times when many a times in village especially there was no birth registration and all those things, so they take the opinion of the panchayat. क्योंकि जनरली इंडिया में होता है बर्थ कब हुआ था पूछोगे तो दे विल से, स्पेशली फ्रॉम द ट्राइबल बेल्ट, दे विल से वो जिस समय बारिश हुआ था या जिस समय अकाल पड़ी थी जिस साल, उस साल में हुआ था. सो मेनी अ टाइम इट बिकम very difficult to ascertain the age. Of course, bone ossification is there, but with that, if we get the panchayat certification also, it also is taken into consideration. It has got weightage in the land of in the courts. So age is a very important factor, and if the accused is found to be a minor, the POXO trial will move to children's court, and if the child has, if the accused has done an adult-like mind, in the POXO cases where the offender is, or the accused is a minor, it will go first before JJB, and JJB will do assessments through the police to ascertain whether the child has done the crime in a childlike mind or an adult-like mind. That is where the age within 16 to 18. Any heinous crime done between the age to 16 to 18, and heinous crime includes POXO. In that, not that all heinous crime will go to court, but the cases where the judge or the JJBs is convinced that the child has done the case in an adult-like mind, only those cases will be referred to children's court or the sessions court, rather than trying it in the JJB. And if judge feels, or the bench feels that the crime done by the offender has been done in a childlike mind, in that case, the case will be tried before JJB, and where the punishment is very minimum compared to what it is when it goes to the session. So, and they easily also get bail in those matters. Now coming to bail. It is it's a right of the offender to apply for bail. But in POXO is a non-bailable offense, and in POXO we have to be very careful while giving bail to the accused, because we have to ensure that if any release of the accused should not be hampering the protection of the victim and the family, will not hamper the further trial in the case, he will not go absconding, and there should be no mental pressure on the victim. So we have to see this fourth category while granting bail, while applying for the court has to see actually this fourth thing, and the lawyers need to bring out to the court notice that if the accused is given bail, so and so problem can happen. First of all, the protection of the victim is at stake if the accused get released. There will be a lot of emotional trauma on the victim. So those are the grounds which the court needs to consider before granting bail. It is, as it's POXO, it is said that POXO is a non-bailable offense and should not be given. But if you see in most of the cases where we see now, bails are given, and the reason being faulty investigation, not filing charge sheet on time. There are also presumption that accused काफी दिन jail में रह के, he has been there in jail for a very judicial custody for a very long time now. He should given bail. Somebody is sick in the family, on that ground the bail is given. But as I say, the POXO is a victim-centric act, we should look at what is the welfare of the victim. Then we should think about the accused. So as a lawyer, whenever there's a bail application put forward from the accused side, from the victim side, we should bring out to the court notice that what harm it is going to do to the victim if the accused gives a bail. And the courts are quite sensitive to it, and judges are sensitive to it, and the bail can gets rejected generally if it brought to court notice what harm is going to happen or it's going to do if the person gets bail to the victim. Yeah. So, but apart from this, there are certain directions which have come out, and that is, if a person puts forward an application in the court for bail, 15 days notice has to be given to the public prosecutor to respond to it. And if the notice is not given to public prosecutor or the victim family is not informed, then the bail cannot be processed. No hearing will be done. Then during the hearing of the bail application, the representative or the victim has to be, or anybody from the victim family has to be present. If they're not informed, if they are not present, then the bail cannot be granted. But still, I see, recently I've got an appeal in High Court in one of the case where in POXO case, family accused has been given bail, and the victim family was not contacted, neither the police contacted nor from the accused, from the court did she receive any notice or any information, and the accused has got bail. So we have gone to High Court, we are appealing against him, and so it's actually a mandate because it's one of the Supreme Court order and has been brought in the amendment also that there has to 15 days notice and the presence of victim or representative of the victim, victim counsel or anybody from the victim family has to be there. So it's a very important thing because bail actually causes a lot of problem to the victim. So and it's against her dignity, and so it's actually we are putting more insult to the family. One hand, we are endangering the life of the child and the family because accused party will of course will come and threaten her and all that. But other side also, if you see, it's actually an insult to when we say that it's a victim-centric act. You're giving bail to an accused who has done a heinous crime, and we are not actually giving respect to the act for what it has been made for. And when we say it's a victim, we fail to protect the very sentiment of the victim-centric thing when the accused in the POXO case is given bail. So we should, as counsels from the victim side, we should ensure that if in case we have not, any of the victim has not got information regarding the bail application filed by the accused party, immediately they should appeal in the higher court. And it's actually it's not permissible under the law that without the presence of the victim or representative the victim, the accused can get bail. But it's happening. It's again a challenge. We need to deal with it. We need to take it up to bring it to the court notice, and we need to take it up at the higher level. If it's happening at the lower level, we need to take it up at the higher level. So that was on the bail thing. Now we're coming to witness protection, victim and witness protection. Now it's a heinous crime, and it attracts penalty like death penalty as well as life imprisonment. So you can understand the kind of pressure the accused will try to create on the victim during the trial. So it's very important that the victim is protected and witness is protected whenever they protect against all ill practices of the accused. When they come forward to give statement, when they're at the police, and there are times when they have got threat, when they have been harassed and things like that. Looking at that, the committee has been formulated where the district SP or the head of the district police, judge from the DLSA side, and the IO. As a committee has been formulated, and that committee are supposed to receive the complaint from the victim, whoever or any victim who is getting a threat from the accused or there's a problem, they can always write to those committee, and the committee needs to meet within 48 hours of receiving complaint. The victim needs to be given whether the complaint is genuine or not. That has to be decided within 48 hours, and accordingly the action need to be initiated, and after 7 days it has to be reviewed. So that victim and witness protection also is very important, and it has been catered in the law, and there has been a committee that has been set up. All this has been done to make POXO a victim-centric act. And the challenges what we are facing, I think we need to go ahead and wherever there are shortfalls and all that, we need to go and appeal about it in the higher authority or the High Court or the Supreme Court. These are all there for trial investigation, and I'm sure if all these patterns are followed, we will definitely lead to the conviction rate. If child-friendly courts are set up, regular hearing happens, victim witness protections are there, compensations are given to the victim on time, investigations is on and done properly, and definitely this will lead to conviction. And that's what I said. It's a fair share. Now, we all demand, not only from government, but also from judiciary, also from different segment. Children have a right to demand this to get justice. That's all I like to say. Thank you. Is there a question that anybody would like raise?
Yes, ma'am. I'll just let you know. I'll just shoot on the screen any questions. Thank you so much. I'll just give me a second. There is a question by Mr. L.S. Gautam. Child Marriage Act would prevail or POXO in case of minor marriage or elopement?
I couldn't hear, sorry.
Mr. Gautam has asked that Child Marriage Act would prevail or POXO in case of minor marriage or elopement.
POXO will prevail. POXO will definitely prevail along with Child Marriage Act. POXO will definitely prevail because it's a Supreme Court judgment in the year 2017 where the court has made it very clear that in case of a child marriage, POXO will prevail. Definitely it will prevail.
Right. That's all I
can to have a sexual intercourse with a child who's below age of 18, irrespective of marriage or no marriage.
Right. So there has been I think you've explained it very well. People have written very useful and informative session. And in fact, another thing has come up very informative. So I've roped in my member secretary too. I think we had a very informative session, and step by step, the way you've taken it, it's really, really, we're thankful to you. Over to you, sir, please.
Definitely, ma'am. It was really a very informative, I'll say, discourse. Because discourse, why? Because you started from how the matter should be investigated, how investigating officers should proceed in collection of evidence, how he has to preserve that evidence, how he has to transmit that piece of evidence to the forensic lab, and from forensic lab, how this should be kept till the time it is produced in court, so that admissibility part of that is not compromised. You have rightly said that forensic experts should be made part of the investigating team, so that investigating officers should get the necessary assistance as to how the evidence is to be collected or lifted from the spot. Then, so far as the trial part is concerned, you have rightly said in the recent changes which have been made in the POXO rules, it is the right of the victim that she should be represented by a counsel of her choice. And in case she does not have the necessary legal assistance, it is the duty of the Legal Service Authority. It is our duty. So we are providing, and all the panel lawyers, they are assisting the victim. They are with the victim throughout the course of the trial. That is right at the stage of bail. You have rightly said that there are practice directions of Delhi High Court also. There are directions that all the courts dealing with bail applications, especially with respect to POXO and rape cases, they have to give notice to the victim. And victim or his or her legal representative needs to be present at the time when bail application is heard. And you have rightly said, I too have one or two matters to my knowledge wherein appeal was preferred before Honorable High Court when this notice was not given during these periods. I'm aware of that. So far as Delhi is concerned, we still have a better picture if we compare it with the rest of India. We have, say, child-friendly courts. we have vulnerable witness complex where a child is kept separately from the accused. Nowhere during the course of trial or during the course of entire proceedings, be it at the stage of 164, be it at the stage of bail, be it at the stage of trial, the child comes in contact with the accused. There is separate entrance for the accused or his relative, and there is a separate entrance for the child. You have rightly said that while recording statement of the child under 164, she needs to be assisted by her mother or support person, and there is a separate channel, there is a separate entry altogether where she will never come in contact. This is the picture I can tell about Delhi. So far as other states, other districts are concerned in rest of India, things are progressing, things are moving, things are improving, that I'm very sure of. Then when it comes to the say victim compensation, as you rightly said that definitely financial instability comes whenever any such incident takes place, especially with a child who belongs to lower strata of society. Uh, the whole family gets disturbed. And so far as we are concerned at Delhi State Legal Service Authority, we are fortunate that we had sufficient funds, we had sufficient support from the state government, and from those funds we are providing timely compensation, immediate, interim as well as final. I can tell one recent example. You must have heard about one case that had taken place in August of Piragadi with respect to a 12-year-old girl, and there was a newspaper reporting that she was raped and was left to die. She was admitted to AIMS. Chief Minister of Delhi, he went to see the girl and had announced 10 lakh compensation. This incident had taken place on 4th of August. FIR in this case was registered on 5th of August. And as per our scheme of Sampurna, the moment FIR is registered, he received FIR on 6th of August. On that very day, one counsel was appointed from our panel only. That learned counsel had moved the application for the interim compensation to the POCSO court on that very day, that is 6th of August. And on 7th of August, I made sure that POCSO court passes an order of interim compensation. And on that very day, that is 7th of August itself, I made sure that amount is released to the account of the victim. So that was done within 3 days of the incident. So this is how we are, I'm not saying that in all the matters we are acting that promptly, but we are making sure that as there are requirements of immediate compensation, there are necessities for, say, medical examination. She or her family members are likely to incur certain expenses for which we should be providing necessary assistance. And these things are taking place. We are doing that. And again, when it comes to witness protection, definitely as per Mahinder Chawla's judgment, a committee has been set up of the district judge coupled with the DCP of the area and chief public prosecutor. So all those witnesses who are vulnerable, they need to be protected because they are only the eyes and ears, and only through them justice can be delivered. Unless and until we get the testimony of because the courts are not there at the scene of crime. It's only through the testimony of the witnesses that we are in a position to deliver justice. So they need to be protected. They are the major stakeholders. They need to be protected. And definitely the committee is taking recourse to all the possible measures and are doing whatever is required of them. And so far as our panel lawyers are concerned, definitely I think after your session, they would be much wiser. They would be, say, inspired also in contributing their bit. So thank you very much for such an exhaustive and the complete, that thing itself shows that say how much work has been gone behind that. So thank you very much.
And that's all. Ma'am, there's one more question. I think that I would just shoot up on the screen. This is by Sudeep Sharma. Whether an accused whose age proof not filed in the charge sheet later found first school record, which mentions that the accused is a juvenile, will the first attended school record be enough without bone age test?
The first age group is what it depends on that. But if the school record, if it's an admission enroll record, the first age group should not be the birth certificate. If it's a birth certificate, then we'll go by the birth certificate. But if it's in school and if it's some other, for example, if it's an Aadhaar, but if the school certificate is there, then it will go for the school certificate. But as I said, it's written in the law. It's been upheld by all the Supreme Court judgments. The benefit of doubt will go to the accused. They will treat him as a juvenile.
Sure. Thank you so much, ma'am. I think people are just writing wonderful session it has been, and yes, this the step by step the way you have explained, and we're really thankful. Thank you to member secretary as well, because it is because of him that we all district secretaries we have the zeal to find out.
I am actually want to say this.
Yeah.
I actually want to say this. Delhi has really done well compared to other states. And sir said we have, in fact, Delhi was the first state where we have exclusive children's court. Not
Sure.
one, but so Delhi was the first state to do so. And victim compensation, yes, sir, I agree with you. The moment there is a case or the cases is referred, immediately the compensation is being released. We are very thankful and grateful to you. My only concern was the judges and the lawyers are of opinion that the amount is only 50,000. It is not 50,000.
Exactly. You are absolutely right. It's definitely not 50,000. Like the example which I have just given you. It was the newspaper report that she was raped and was left to die. But
You're right.
But her statement was not recorded by the police, and neither there was any medical opinion that she was raped. So
Right.
in that case, the only material which was there before us was that injuries to the minor. So as per that Nipun Saxena's and as per that victim compensation, the maximum compensation that was payable was 5 lakhs. But
Right.
interim measure, I got 2 lakh rupees release. So it is not 50,000. So at that
Right.
within 3 days, 2 lakhs were
So
released.
that is the problem I have seen in Delhi. Most of the trial courts, they keep it that as per the Delhi Victim Compensation Act available. But Delhi Victim Compensation Act is only for women. I mean, women and other things. Children are not.
Yes.
Till the time the guidelines comes, we have to consider that.
We
So,
that only. Yes.
but thank you, sir. Delhi is doing a lot. And we are grateful that we have you, sir. We are thank you so much.
Indeed. And that's what I was saying, that our zeal and everything, because I would like to place like our victim compensation in every district. So every meeting when we have with our member secretary, ask us how much number, what's going on. So he's only asking, so he's so regular with it. And actually the number has come down very drastically. And now sir rightly said that we actually do it in 3 days, 4 days. And there are a lot of instances, though we don't publicize it, but we know how we perform under his guidance and supervision.
Definitely, I regularly, on regular basis, I keep on asking them, keep on pushing them that you should not be keeping any applications pending with you. And the thing is that it can be achieved only through a team effort. And I'm fortunate that I have a dedicated team of secretaries with me. And only because of that, it is possible, whatever bit we are doing so far as legal service authority is concerned. And I just wish to make that particular, you referred to that judgment of 2013 by Honorable Supreme Court regarding missing children. I did mention about that judgment last time also, but that really was a wonderful judgment. The way Supreme Court has said that, and a legal fiction was created by Supreme Court, because from the side of prosecution, this was the contention that as no cognizable offense has taken place, how can we register the FIR? Supreme Court created that legal fiction. It says that whenever a child goes missing, you just see that he or she is either kidnapped or trafficked, register the FIR, investigate, and then you can file cancellation in case subsequently you find out that she went missing on her.
This was a case where continuous hearing happened. Justice Altimas Kabi, Justice Bobde, I mean, for 3 days continuously they sat on. It was our case. We went to court with this case, and it was remarkable.
Yes.
It was about revolution in the country. It talked about support person. It opened all the policy gaps that were there. So it was a revolution case.
Yes, definitely. I like reading that particular judgment again and again. It is really a wonderful judgment and a wonderful effort from Bachpan Bachao Andolan.
Thank you, sir. It's a pleasure.
Thank you.
So we can now, thank you so much, and we conclude. Right. Thank you.
Thank you.